Chapter 4 delves into the different types of evidence. So relevant evidence is evidence that makes any fact important to the case more or less likely. Only relevant evidence is going to be admitted in court. Relevant evidence is considered probative if it offers some proof of a fact that did or did not occur. Probative value means it's sufficiently useful to prove an important fact, and we're always weighing this against any prejudice that this information might result in. Sometimes relevant evidence is not admitted, and that's because it's been obtained in violation of the defendant's rights. It might be a violation of one of the hearsay rules, or the information is considered privilege, and therefore not admissible. So what makes something relevant? As I mentioned, relevance is when it tends to prove or disprove a disputed point or issue in the case. So one key issue of relevance is what is at issue in the case. All disputed facts that are required to establish the elements of the crime charged and the defendant's guilt beyond a reasonable doubt. Facts necessary to establish the defense are also at issue. So say the defendant admits to something, such as a prior conviction, then those facts are no longer at issue, and so no evidence can be submitted to prove facts that are not at issue. As I mentioned, another key issue here in admissibility is its probative value. The evidence must make it appear that a fact probably occurred. Any evidence that might have some impact on the jury. If an attorney makes an objection based on lack of relevance, the judge then will have to decide if the evidence will be admitted, and this is made on a question-by-question basis. Evidence that is not relevant is not admissible. An attorney then could object and require the judge to rule on the relevancy of any evidence. If there's no objection, no proof of relevancy is needed. Remember also, we want to get those objections on the record because if we feel that they're a constitutional violation or an issue of law, then we're going to want those on the record for a later appeal. Material evidence is evidence that has some logical connection to the facts of the trial and affects whether they can be shown to be true or false. Evidence that has no connection is immaterial and inadmissible. So exclusion of evidence is really a balancing test. Judges are looking at the impact of the evidence, and they're going to look at the federal level, Federal Rule of Evidence 403. So this balancing test is used to determine if the value of the evidence outweighs any problems it could cause at trial. Relevant evidence is not admissible if it would be unduly prejudicial due to its emotional impact. And this can include things like the defendant's prior convictions. Usually it's only slightly relevant, yet it increases the chances the jury will believe he is guilty, and so therefore it's not allowed in the case in chief. If the defendant does take the stand, then that information could be used to impeach him, and the information can be used in sentencing. Another example might be pictures of the murder victim. They may arouse hostility, but might have greater relevance to the case. However, the judge may limit its admissibility and restrict the size or number of photos that are admitted. So typical cases of exclusion include things that are unduly prejudicial because they're highly emotional, prior convictions that are not closely related in manner or time to the current case, and evidence that distracts from the main issues at trial. Two other types of evidence to think about are cumulative and corroborative. Cumulative evidence repeats other evidence or facts, and this is less likely to be admitted. Corroborative evidence adds new facts and confirms other evidence and is much more likely to be admitted. Direct evidence is evidence that conclusively establishes something is true if it is believed by the jury. Direct evidence of a fact and issue is always considered relevant. Circumstantial evidence is evidence that indirectly proves a fact. It requires the judge or jury to take information that it's been given and make an inference or a deduction. It's not grounds to object to the admission of evidence simply because it is circumstantial. And we'll talk about this in a little bit more depth in the next chapter. But think of it this way. Imagine you go to bed at night and there is no snow on the ground. You wake up in the morning and there is snow on the ground. What conclusion would you draw? That it snowed while you were sleeping. That is circumstantial evidence. An inference is a logical conclusion based on facts. As we discussed before, testimonial evidence is evidence given by a witness under oath or affirmation. It can occur in court or before court, often in a deposition. But in order to be testimonial evidence, it has to be done under oath. This is really critical piece of evidence. Real evidence is any physical evidence that itself plays a direct part in the incident in question. This could be demonstrative evidence, so charts or maps that someone might use, as well as tangible evidence, evidence you can touch. Substitutes for evidence include stipulations, judicial notice, and presumptions. Stipulation is an agreement between both sides, both the prosecution and the defense. They'll admit to one or more facts and evidence. They can be written or they can be oral. They're typically made before trial, often to simplify or speed up proceedings. And usually they're made when a fact is easily proven by the other side. Judicial notice is a procedure whereby the judge instructs the jury to conclude a fact exists. This might often be used for state laws or information that's in a court record, so the judge will notify the jury that XYZ is the state law. A presumption is a legal inference or assumption that a fact exists based on known or proven existence of some other fact. So the basic fact is what is necessary to establish a presumption may exist. The presumed fact is what may be assumed if the basic fact exists. And here you can see a display here of Francis v. Franklin from 1985, the defendant was on trial for capital murder. As a prisoner, he had escaped custody and fled into a private residence. The defendant shot through a closed door, killing the deceased when the victim refused to turn over his car. At trial, the defendant's sole defense was that he did not intend to kill. The judge's instruction allowed the jury to presume an intent to kill. The Supreme Court overturned this conviction, as such presumptions cannot be mandatory. Traditionally, for a crime, you had to have both the physical act and the requisite mental state, referred to as mens rea. However, it seems we're moving now more towards an approach of strict liability. There are 3 constitutional limits on presumptions. A presumption must be based on a logical assumption rather than mere policy. When used by the prosecution, the basic fact must be established beyond a reasonable doubt, and the presumption cannot shift the burden of proof to the defendant. In re Winship, from 1970, during a juvenile hearing, the state sought to convict a teenager under a lesser standard of proof, preponderance of the evidence. The Supreme Court ruled that every essential element of a crime must be proved, and it must be proved beyond a reasonable doubt. There's 2 types of presumptions, rebuttals and conclusive. A rebuttal presumption may also be divided into strong and weak. For each, you still need to prove the basic fact before the presumed fact can be considered.